Welcome back, everyone. In today's video, we'll be following up on a familiar figure I've covered before, sovereign citizen Leonard Blatt. This time, we're looking at his pre-trial conference, where he once again launches into his usual sovereign citizen arguments. However, things don't go quite as he expects, as the judge quickly puts him in his place. Let's dive in.
That just doesn't change the court date. It does change. Mr. Blatt, can you come on the Zoom call?
Yeah, can you hear me?
I can.
Okay.
So this is on for pre-trial. So you don't have an attorney, is that correct?
I'm not sure I need one yet.
Okay.
Can I have your name? It says DC.
Your Honor, if I may, a couple of things.
Yeah.
First of all, the state has received a supplemental report and is prepared to establish probable cause at this time. And then also, if the defendant is electing to go pro se, the state would request a pro se colloquy.
Okay, I think that may have already happened. But in any case, so Mr. Blatt, right now, this is on for a pretrial, which is the opportunity for you and the state to discuss the case or maybe come to some sort of resolution. And then it can be, and right now it's set for trial. Otherwise, it would continue on to trial. Your trial confirmation is October 22nd. And then the trial itself would be October 29th and 30th. So I guess where do you said you don't think you need one. Which tells me that you don't have one at the moment. So I guess how do you see this case progressing and playing out?
Can I have your full name and the prosecutor's full name?
My name is Sam Meyer, and the prosecutor's name is Ms. Kidmacher.
Is it M-E-Y-E-R?
Yes.
And the prosecutor's name, again, is...
Last name is Kidmacher.
Okay. And first name?
It's Gabby.
Okay. And can I see your oaths of office and official bonding information?
Well, again, speaking only for myself, the answer to that is no. I don't have it on me. I don't carry around with me. I haven't. It's not necessary for me to post my bond. And, the person who needs to, I'd like to know some information from you as to where you see this case headed.
When the officer stopped me, if I were to tell him that I have a license, I have insurance, I just don't have it with me, I don't think that would cut it with him. It's important for a driver to have his license and insurance in order because operating a motor vehicle is a potentially hazardous occupation. The same is true with being a judge or a prosecutor. It's a potentially hazardous occupation because people could get hurt. They could go to jail unlawfully if something goes wrong. So a judge needs an oath of office, which is anomalous to a driver's license. And
right.
The bond is equal to the insurance that a driver would need to have.
You can come up with as many analogies as you like, but that doesn't make them true. The law is very clear. There are statutes that require drivers to carry their license and proof of insurance at all times. However, there are no statutes that require court officials, including judges, to carry their oath of office or bond on them wherever they go.
So I do have a oath of office. It's good at the auditor's office. If you want to go there and get it, you can certainly look at it. But like I say, I don't carry it with me. I don't have it on the I don't have it posted on the wall. I don't believe I'm required to. You are required to have a driver's license when you drive a car. But I don't, we're going down a rabbit hole, which really isn't that productive for you, Mr. Blatt. I'm trying to figure out, where you see this case headed. And it's either going to be set for trial or there's going to be some sort of resolution. And if you think you've identified some issues with me or you haven't seen my oath of office, if that's an issue on appeal you want to raise, if you get convicted, you can certainly do that. But we're not going to spend a lot of time on, things that don't really matter with regard to your case. You might not believe that it doesn't matter, But it really doesn't. Right now, you're the one charged with driving with license suspended in the third degree. Your options are go forward to trial, which I've told you when that's scheduled on October 22nd for trial confirmation on October 29th and 30th. And that's kind of, so I guess I'd like some answers from you as to where you see this case headed.
Okay, you just said you don't want to spend a lot of time, but if the prosecutor wants to spend 3 months of my time in a jail, then you have to afford me the time I need to get due process. Now,
Yeah.
at the beginning of this Zoom hearing, I heard you say that the state is charging me, but the paperwork I've been giving says the city of Tumwater is charging me. Could we clarify that?
Yeah, I can clarify that. And that was the mistake on my part. You are correct. It is the city of Tumwater.
But the city of Tumwater is franchised by the state of Washington, right? And it's using Washington statutes to prosecute this case, right?
I don't know about the franchise aspect of it, but it is a municipal court case from the city of Tumwater. A lot of times municipalities incorporate on criminal codes and misdemeanors, they'll incorporate the revised code of Washington into their municipality with the law within that municipality. So yes, it could very well be prosecuted under a statute from the revised code of Washington.
Well, that raises some concerns with me because I see to your left, you have the plaintiff's flag behind you. And so are you a neutral entity or are you part of the prosecution?
Yes, I'm a neutral entity. I like to think that, yes.
Then why do you have the prosecution's flag behind you?
It's not the prosecution's flag. It's the flag for there's a flag from the United States of America. There's a flag from the Washington state, and then there's a flag for the county. I am a Thurston County District Court judge. I elected and have jurisdiction within this county.
But the state of Washington enfranchises the city of Tumwater to prosecute people under its statutes, the state statutes.
For certain crimes, the answer is yes, but for others, no. Some offenses, such as murder, fall under state law and are prosecuted by the state. Others, like parking violations, may be handled by the city. However, that doesn't mean the state has transferred or franchised its authority to the city to enforce state laws. It simply means the city manages its own ordinances.
So
I don't agree with your terminology there in terms of what they franchise. If Tumwater is a municipality, they have some discretion as to how they can choose to enforce laws within their municipality. One of the ways they can do that, and they're not alone in this, a lot of cities do this, not everybody. Lacey, for example, has their own municipal code, but Tumwater might not. They might adopt the RCW for things like driving with license suspended in the third degree, DUI, and misdemeanor and gross misdemeanor things and things of that sort. Of course, felonies that obviously would be under the revised code of Washington, and that would go to Superior Court. That this is limited jurisdiction, and we only deal with misdemeanors and gross misdemeanors. We're contracted to provide court services for certain municipalities within Thurston County, including Tumwater, Lacey, and to name a couple, and that's why you're here. That's how you're here.
are you going to be the judge throughout all the hearings in this process?
I don't know. No, we have a rotating schedule and may or may not. I'm just the lucky one today.
Oh, this is going to put a burden on me to check all the judges' oaths of office and so on.
No, it's not. At the end, don't worry about that. Like I say, our oaths of office are on file, and you can go look at any of them anytime you want.
Okay, I've been given this paper by the court. It says criminal traffic.
Yes.
I'm very upset
Yes.
about being called a criminal. I'm not a criminal, and I want to clear my name. Believe me.
Well, you haven't been convicted of this charge yet, but driving with license suspended in the third degree is a criminal charge. It's a simple misdemeanor. It carries with it a maximum penalty of 90 days in jail and $1,000 fine. As a practical matter, that would be highly unusual for anybody to receive that sort of jail time for a charge of this sort. But driving with license suspended is a criminal offense. It just is, and that was done by the legislature. And
Now, driving and traffic are commercial terms. I mean, you could check it in Black's Law Dictionary. And the police narrative says that I had a passenger in the car. Passenger is also a commercial term. A passenger, according to Black's Law Dictionary and extensive case law, says that it's a customer who pays you to transport him, which is basically trafficking. There's nothing in the police narrative that says that to support the presumption that I was engaged in any commerce or traffic. So the case should be dismissed on that basis.
No, that doesn't matter. If you get behind the wheel and drive a car, you need a license. And there are certain rules and there are certain things happen that can cause that license to get suspended. If it gets suspended and you get caught behind the wheel driving and the state can prove it, then you would be found guilty. Those terms of, Black Law Dictionary, whether they call that a passenger or not, I'm not really sure, but the law that applies in this case, like I've told you before, is the Revised Code of Washington, which deals with licensing and when people can drive and when they're eligible to drive. So all that's things you say about, and again, you might not believe me, but those things you talk about, whether it's a passenger, whether it's a commercial term, none of that matters. The only thing that matters is, were you driving and were you validly licensed, or was your license suspended? And that's it. That's what this case is about.
Sir, I was traveling, not driving. Driving is a commercial term.
Okay.
At the time, now I know that anything I say can be used against me in court. I'm fully aware of that.
So hang on just a second. Well, it can, but you shouldn't admit that. If by traveling you were in an automobile and conducting that by having an engine running and applying pressure to the gas and brake and turning the wheel, whether it's traveling or driving, that's kind of like, 6 of one, half dozen of the other.
Sir, I need to make something very clear at the very outset. I'm not going to deny that I was traveling in my private property automobile on the date in question. I'm not going to argue. I'm not going to fight with the prosecutor about what the prosecutor wants to fight about at trial. My defense is going to be something completely different. Now, I noticed something on the website for the court. It says jury instructions or jury guide.
Okay, so hang on just a minute. Before we get there, can I take that to mean then that you wish to go to trial on this?
I wish to be left alone.
Admitting to the jury that you actually committed the crime you're being accused of is certainly a bold legal strategy, one that has absolutely no chance of working. Still, if that's the approach you want to take, don't let me stand in your way.
Okay, well, that's what everybody wants. But right now, where you are is you're charged with the crime of driving with license suspended in the 3rd degree. So again, I've went back to this before. Your options are either come to some sort of resolution with the city, or you're entitled to a jury trial. And then if you win, and you started mentioning, I want to stop you when you started saying things about jury instructions. And that means if you wish to go to trial, you can do that. And but we're going to have a different conversation about your ability to represent yourself, which you certainly have a right to do. But I need to create a record that you're doing that, knowingly and voluntarily with open eyes. The possibility is still in place to have an attorney appointed to represent you. But when we started this conversation, I'm not sure that I need one. Most people, when they're charged with any sort of criminal offense, and again, this is a criminal offense, they take advantage of when they're offered an attorney at little or no cost. But again, that's entirely up to you. But what I need from you is a decision point on how you want to handle this case. Either come to a resolution or go to trial. And if you go to trial, then we're gonna, which is fine. Trial dates are set, but we're gonna have a conversation about a few things before we get to a jury instructions. So again, I need some input from you as to what you wish to do.
I only participate in fair trials, and I have concerns about whether I can get a fair trial in this court. Can I?
Okay. Well, the trial, if it's a jury trial, the people who are going to determine your guilt or innocence will be 6 jurors who will be impaneled from the jury rolls within the county. and it'll be up to them.
There'll be 6 jurors and an alternate juror, right? So that's 7,
Yeah,
right?
typically, yes.
Well, this jury guide that you have on the website says that it's the juror's job to listen to all the evidence at trial, and the judge is to deal with legal issues, not the jury.
That's true.
That concerns me about whether I can get a fair trial, because the whole purpose of a trial by jury is to consider issues of law. Otherwise, why do we need a jury? Because
Right.
I've already stated I did the act. I traveled in my automobile on the date in question. I'm not going to deny that. That's the first thing I would tell the jury if it goes to trial.
Well, that part's simple. It's called contempt. If a judge has already ruled against a particular strategy and tells you not to pursue it, yet you decide to push forward with it anyway, you're not making a clever legal move. You're putting yourself in contempt of court. Redefine what the definition of a driver is. Then he can potentially stop the trial, throw you in jail for contempt, and then continue the trial when you're done serving your jail time.
Okay. And I'm going to bring up to the jury the issues of law. My question to the court is, how would
here in a second, I'm going to stop you for a second. You're very wrong about something. Okay, you are very wrong about something. The jury does not decide issues of law. The judge does. The jury decides issues of fact. The jury decides what did happen or not happen. That's what the jury decides. The jury's the fact finder. The judge decides what law the jury listens to. And that's just the way it is. And so when you say the jury decides the law, that's not correct. That's, there's no court in the country that where the jury, in this country anyway, where the jury decides what the law is. The judge decides what the law is. And you can look at any court in any state, in any jurisdiction in the union, and that's the way it is. And so the judge, and then the judge will, in following the trial, following the evidence portion of the trial, the judge will instruct the jury on what the law is, and then the jury determines whether or not that person, you, did or did not do what you're being charged with. That's a fact inquiry. And what you're being charged with is driving with license suspended in the 3rd degree, and the jury's going to decide, did this happen or did it not? And if you have issues with the law, they're not fair, you might think this is unconstitutional. I've heard many times people think that, it's not constitutional for a state to require people to get licenses. It is. I've heard that, that there's some, the right to travel is being impinged by the requirements of a license. It's not. All of those things have been looked at by courts much above me, have decided that that's what the law is. And any instruction you're going to get on the law, or the jury's going to get from the law, has all been vetted in front of, courts of appeals and the Washington State Supreme Court. And that's the way it is. But you need to be clear. The jury does not and will not decide the law. The judge will determine that. And what I was going to say to you in advance of that is, you might not get to present. Maybe this is why you think you don't get a fair trial. Some of these legal issues you wish to argue, you might not be able to do that. Probably not, because that's just what the law is. And I know what the law is based on my experience. And I may or may not be the trial judge if it goes that far, but I just know that to be the case. So we're going to stop here for a second because but don't leave, because it's at 2:30. And we have some other people coming on at 2:30. We're going to take care of those cases, and then I'll come back and speak with you some more. All right?
I understand you believe all that nonsense, but I'm going to have a trial by jury, not a jury trial. A jury trial is 6 people that only consider the facts, and basically juries have been neutered since the rules of evidence have been implemented in the 1936. But this jury is going to hear the law as well as the facts, and I'm just curious. I would like to know how the judge would, how the court would stop me from communicating.